Okay. Our guest for this hour is seated. It's good to see you, Wakili DANSTAN OMARI. Good morning.
Morning. Am I seated or am I standing? It's only that my height is small.
Well, the law is very clear.
Even in Mwangaza's case,
the law is
it's
very
not clear.
Well, you guys always want to tell us the law is very clear. Now, whether you are seated, where your posterior is...
That is our tool to make money.
I know. You say it all the time. Even when it is clear as mud. The law
it can never be clear. It is clear as per your instructions. Your client's instructions, the law is always on his side or her side.
Okay.
And the advocate on the other side, the same. But when we are at Spice, it is very clear that we are at the epitome, the apex of the radio station of the country.
Unatupakia siagi.
Mimi nimeambiwa na watu. The base is the apex.
Okay.
There is the Supreme Court. And the radio stations are gauged in terms of seniority. Spice is the supreme.
Asante sana. We'll take the compliment and we will raise you a proverb from Chad.
Yes. What you've just done, and we are grateful, is what we say in Kiswahili, unatupaka siagi. Na tumeshukuru. When you befriend a chief, that's how the statement begins, and that's how the proverb begins. Remember, he sits on a rope.
You can't calculate the proverb, Wakili. You can't.
Are you Googling?
You can't pull out your calculator and put the proverb and then say, calculator, tell me what it means.
I want to know whether it is his or it is a quote.
It is not mine. It is a
he
quote.
has disowned that is not his.
It's not his.
No, it's from Chad.
It's from Chad.
Yes, I am merely regurgitating what the Chadians had said about a certain matter.
What do you think the Chadians are saying, Wakili?
I'm not a Chadian, but what they are saying is exactly what they mean.
No, you can't do these things here.
It is very clear
Not,
that it is from Chad.
we want to know how would you interpret that proverb?
Yes, your thoughts, really.
Let's repeat it for the benefit of those who didn't hear what it is.
When you befriend a chief, remember, he sits on a rope.
When you befriend a chief, the day you intend to get the person who decides on any matter, because a chief in Chad must be the person in authority, whichever authority, church, home, everywhere. Then remember, he's sitting with a rope, or he's sitting on a rope. He can sit, decide to hang you. He can sit, decide to give you a rope to move to the destination that you want. So to me, it means be very, very, very careful when you are dealing with a person in position or in authority.
See?
I didn't get a chance to brag.
No, but you've done it very well.
Yeah.
Oh,
yes.
Imagine.
Yes.
I'll swear on David to be a Chadian now.
Imagine. Okay. So, Karibu sana. Good to have you here again. Of course, you're no stranger to the seat, but it's hot anyway because there are lots of issues hotting up. And we're looking at impeachment and the rule of law.
Yeah.
We've had conversations previously about, should it be so easy or difficult to impeach one in a position that is impeachable? One in an elected position in country then is impeachable, and what we've seen with the serial impeachments of still Meru Governor Kawira Mwangaza. And we have to ask for an overview of where this sits with the law today. We saw a series of things happen. For the third time, the MCAs brought her brought an impeachment motion against her. It sailed. Senate sat in record time. Submissions were heard. Decision was made. And then at midnight, her counsel went to court essentially under a certificate of urgency and said, we're appealing this. Court said, okay, we can take that into consideration. In the meantime, she remains governor because otherwise what would have happened is that as of tomorrow, or rather of yesterday morning, she would have vacated the seat, deputy governor takes over, right? High Court says, okay, well, we're going to hear this come September. In the meantime, carry on with your duties. What is going on?
Well, I love to disclose that Governor Mwangaza was my client in the first impeachment, for the benefit of the viewers and listeners. What is happening is, before the court spoke, was a political process. Once the court was seized with the matter, it becomes a legal process. The proceedings in Meru County Assembly were political in nature, but they had to comply with provisions of the Constitution and the law. The MCS impeached the governor 3 times. 3 times, the Senate twice, it did not agree with the MCS.
Yes.
The 3rd time, it has agreed with the MCS. The standard of proof at the MCA level and at the senator is not the standard of proof that the courts will want to see. The law has provided for grounds to impeach a governor. Those grounds, when they are being dealt with politically, the vote, it is about the majority votes. Reasons for impeachment are never taken care of seriously. If the Senate and the Assembly decides that they don't want the lady because she has long hair, that will be a ground for impeachment. It is a political process. But now the Constitution provides for legal mechanisms to check whether there is an abuse of the due process in the County Assembly and in the Senate. Those who are alert, so my good senior lawyer, as a Ongoya, disappear from the proceedings after he realized that the politics has already decided his client must be impeached. He must have gone to prepare the pleadings. A good lawyer will always have a plan B. In the event or in the unlikely event this thing happens, do I have a recourse? So the lawyers of the governor had prepared for, in the unlikely event they lose. So they made their pleadings. They only inserted the number of votes and filed that certificate of urgency. The court acted within the law, understanding and taking cue of what happened in Wajir when the governor was impeached, what happened with Governor Sonko, where impeachment ended. And there was a judge waiting at 8 a.m. The gazettement was done at midnight. And the new governor, Kanan, was sworn before the courts started sitting. So the courts have taken notice of how politics is played. So what I will advise and what I saw is that the people wanted the governor out were not smart. The lawyers outsmarted them. Because if they sought and looked at the history of how impeachments are done, the deputy governor was supposed to be sworn in at 3 a.m. or 4 a.m.
Okay, hang on. So we're looking at a process that went well into the night, into the morning.
Yes.
Okay. So what you're saying is that there should have been preemption on the side of the courts.
No.
Or there should have been preemption on the side of the county government, or preemption on the side of advocates, to make sure that certain processes took place in order to avoid an appeal going to court.
Because Amason King actually did gazette.
Amason King is a senior advocate. He was gazetting what has already been overtaken by events.
All right.
There is a court order stopping execution of the decision of the Senate. Where the dilemma is that a judge has stayed the implementation of Governor Kawira's ouster. It is another judge who can only swear Kawira in. No judge will disobey an order of another judge. If it was a senator, or if it was the speaker of the Senate going to swear in Kawira, then we will say they will defy and proceed with that. What we are saying, several lessons that are coming out is that we need a law to say after impeachment. An impeachment is like a general election. The president is not sworn in immediately. The Kibaki fiasco, where elections were declared and Kibaki was sworn in at night, we cured it by saying after the election, there are days specified to allow anybody to move to the Supreme Court to challenge the decision of IEBC. Once that decision comes out, then a program for swearing in of the president is specified, the time between 10 to 2. So there is that lacuna in governor's position.
Is there no way that would have been overturned? Because here you are saying that a particular scenario could have come about, because you're saying that somebody should have been prepared to swear in the deputy governor, right? To swear in the deputy governor at 3 a.m.
There are two sides of this coin. The lawyers who wanted and the MCAs who wanted the governor out slept on their job. They have lost. The lawyers who are defending the governor have pulled a fast one and succeeded to secure a breathing space for their client.
For 15 days. Well, I mean, what happens after that?
If you look at the Embu fiasco, the former governor of Embu was impeached from the Embu County Assembly, was impeached at the Senate. He got the first reprieve of 15 days at the High Court. He stayed in office until the next general election. Because from now, that matter being heard, the lawyers of the governor will not be ready to proceed. They will be raising very many applications after applications. The date that matter is going to be argued, I'm sure the lawyers will be filing another application saying this matter raises very constitutional heavyweight. We need a free bench judge. That matter must go to the Chief Justice.
3-judge bench.
To decide. That is time. From there, it will proceed. Remember how long the BBI took? 4 years. Uhuru started it with black hair. It ended, he had white hair.
Okay.
The finance bill started. We are still in the drama at the Supreme Court. So, Kawira, and I know the lawyers of Kawira are sharp, they are likely to sustain her through the court orders for another 2-3 years. And she might be seeing 2027 as a governor.
All right.
The legal process is slow, painfully slow. It is what Kenyans chose.
Let's quickly look at why she was impeached. I think it's important because people are arguing that we shouldn't make it so easy to impeach, whoever is in positions that can be impeached. But looking at what the speaker declared, Mwangaza was removed on 3 grounds of gross violation of the Constitution and other laws, gross misconduct, and abuse of office. I mean, we uphold our Constitution here, and when such allegations are brought before the Senate, Kenyans need to question, not once, not twice, but as an advocate and understanding this and being her advocate, prior, why would it be so easy to push this? These are allegations we see over and over again. It's always gross misconduct. It's always, a violation of the Constitution. Some would question why it's always so easy to be impeached based on these 3 allegations for most people who are, impeached or are foreseeing impeachment.
The 3 grounds are grounds specified by the Constitution.
Yes.
That those are the only grounds available for anybody to impeach the president, to impeach the deputy president, to impeach the governor, and to impeach the deputy governor. The law provides for that. The question that is there is the threshold of the evidence to prove that.
All right.
At the county assembly, none of those sitting as the judges, the MCAs, have the capacity and training to verify the veracity of the evidence. At the Senate, there are lawyers there, but they are not qualified in terms of evaluating and making judgment of the evidence produced. As I said, that was a political process. Whatever the politics, they'll define what abuse of office means. It will be defined from a political angle. Now that we have entered the court, the Munya case and the governor from Embu case has defined what you need to prove, the threshold of the evidence. And that is now when we are going to see those alleging what they alleged. Can they prove legally? The proceedings in the Senate, for those ones Kenyans who viewed, the lawyers of the governor were not addressing the senators. The lawyers of the governor were asking questions that ought to be dealt with in the High Court. Was there public participation? The minutes from every ward appeared to be the same, copy-pasted. Only the names of the attendants changed. Those are the questions that the court will want to see. Who are these people who attended? Can they prove they were there? The lawyers might be asking for their data, mobile telephone data, to bring by geodata whether they were present in that meeting, to prove that. So the threshold in the court is different. It is going to be a bloodbath for those ones who made the allegation.
If they ever get to it, because what you've told us is that it's possible for lawyers to be filing application after application. Will it ever get to bloodbath status? By the time we know it, election 2027 is hitting us in the face.
The High Court must make this decision, I'm sure, before 6 months are over. Then we move to the Court of Appeal.
All right. How long?
Then they move to the Supreme Court. Both parties have no truth. Remember, this is a matter that was even sent to the Njuri-Njeke. And the Njuri-Njeke said the type of animosity from both sides, we don't want to settle. I wish they even came at spice. You will have raised the hearts. I've been in this matter. It is life and death for the two sides. They cannot agree. And because they can't agree, the Supreme Court will decide. What I'm saying, Kenyans wait for the drama in court. It is a long haul. It is not an easy matter. And courts are not going to deal with this matter. Remember, election petitions have timelines.
Yes.
Impeachment motions have no timelines.
So we can just keep doing this thing.
It will proceed like any matter in court. Why is this matter life and death? I want to tell Kenyans this. All crimes in this country, murder had the severest punishment. That was life, imprisonment, or to be hanged. The Murwatetu case now has made the punishment of murder, you can be jailed for 1 day. You can be jailed for 10 years. You can be jailed for 4 years. What is the punishment for impeachment? It is a life sentence that you will never hold any public office. All your life. Sonko can never, Waititu can never hold an office forever. You can't appeal anywhere. Remember, when Sonko, the Supreme Court threw him out, I rushed to the East African Court of Justice myself.
Yes.
Because this is a punishment you are going to serve till death. This is a punishment where it is a political decision. People don't like your beard and they just remove you.
Is it? Does it get that trivial, really?
That is how serious.
Triviality is...
Politics is based on interest at a particular moment. Politics, shortly, the political machinery was seeing the Raila faction as the bad boy. The team was bad. They were the ones being arrested. Today they are in government, they are turning to be arresters. They are arresting those who are arresting them. Those are the politics of the day. It is based on emotions. It is based on interest. It is not based on any logic. It's not based on any scientific
And yet
reason.
we invite the law to be the vanguard of this entire process. And we're saying that it's not based on anything legal, but you're going to bring in the law
Today,
as the referee.
After the politics has done their drama, the law now has taken over. You have alleged, proof.
Are we confident that the law is not, going to be compromised? Because we've seen a number of times people saying, well, the parliament, which is supposed to be the supreme organ and is constitutional in as far as legislature is concerned, has been, of course, they say, bought by the executive. There have also been, concerns about the position of the judiciary in as far as its independence is concerned, and how strong the force from politics can be. And perhaps it's just good to hear then, you've said that the law is the law, it works and anchored on the constitution. Kenyans would ask then, how confident are we then that the hand, which is claimed here on the papers, State House, etc., wouldn't have an extra hand as far as the judiciary corridors is at this state or position or level we are in with Mwangaza?
Can I ask a question? Is there any arm of government where there is no politics?
Is there?
It's a simple question.
The judiciary has no politics.
Wakili.
The judiciary has no politics.
Okay. Right.
The judiciary will decide matters based on the evidence produced and the law. The layers in the judiciary are 4. So that if you infiltrate one layer, you will have to infiltrate the remaining 3 layers. At the judge's level, one judge will hear the matter. There's a possibility of an empanelment of 3 or 5. At the Court of Appeal, 3 judges must sit with a possibility of empanelment of 5 judges or 7 judges. At the Supreme Court, 5 judges must sit with a possibility of 7 judges sitting. So anybody who thinks that this is a matter you can be able to get one judge to give you a favorable decision, that is a temporal reprieve. That reprieve, if not based on law, will be challenged at the higher court.
Okay.
So that those filters, Kenyans put them there because the judiciary, for the first time, is that the judiciary is a permanent arm of government, while the executive and the legislature are casuals, employed for 5 years, and they go home.
Okay. DANSTAN Omari, even as we get in, because I know Anki has like 53 million questions, but should it actually be easy or difficult? Because when did the impeachment motion come to? Last week. And it was clear that the county assembly had met, 1, 2, 3, impeachment motion, delivered, she was impeached. It had to go to Senate. By Monday, submissions were made. Tuesday midnight, the thing is done. It seemed like an easy process because of the time. It seemed as though it was something very easy that happened. So one of the questions that have been asked by governors, interestingly enough, and that they want to be able to say, the Council of Governors did come up with something a couple of years ago, led by Anwai Guru, and they said, you know what, if you want to impeach a governor, let this person work for at least 2 years. Let's say that any impeachable offense, whatever that you think you want to bring, let them have been in office for 2 years. Then in the 3rd year, if you bring something like that, while that is going on, allow them to work for the 4th year. By the time you're done, there's nobody you're impeaching. So the overarching question is, should it actually then be so, and I'm going to put easy in quotes, to impeach an elected official, governor, deputy president, whatever? Should that process be that easy?
1, the Council of Governors spoke. Those are aggrieved parties. They are casualties of impeachment. So they were conflicted and they took a position for self-preservation. 2, the people who have this power to impeach are the same people who make the law for impeachment. Parliament, Senate and Parliament make the law. Constitution does not provide for the modalities the law, the procedures, what is supposed to be done. It provides for the threshold, the principles for impeachment. Parliament has not made a law that favors the rule of law. Parliament, being the Senate, they regulate themselves. That is why once a matter arrives there, they can say, we are hearing this matter now, and we are deciding this matter now. Among the issues that have gone to court is one, was the impeachment allowed by law. Kawira, Mwangaza had a court order stopping the Meru County Assembly from proceeding. They proceeded in total disregard of a court order. That issue has been raised now. It was also brought. They argued it and dismissed it. They argued it in Senate, the Senate dismissed it. That is one issue. If Parliament cannot follow the law, but they want the law to be enforced against Kawira, it is going to be a big order. Number two.
I'm sorry, I need clarity on what preceded that particular order on the county assembly, or what you just said earlier on, when the Senate acted in disregard of that order. What preceded that order, so that we understand why the court declared that in as far as the county assembly is concerned?
When the notice to start impeachment proceedings was issued by the Speaker of the County Assembly, Kawira got us an order to stay the proceedings.
Okay.
All right.
Why?
Under the law, a matter in court cannot be discussed in Parliament under the rule of sub judice. That matter must wait, and a decision is done, then you can discuss it in Parliament.
So then why was that not upheld?
The Assembly and the Senate was blinded because of politics.
So there was a contravention of the law?
Complete.
So how come that was not raised?
It was raised.
But then nothing was dealt with.
It was dismissed.
It was dismissed, yeah.
The Speaker dismissed it. Both speakers dismissed that legal argument. The same argument are the grounds they have gone to the High Court and said, this process is a nullity because the procedure were not followed. The process is illegal because the court had stopped it. You cannot legitimize an illegality. So all these things that has been done, we might hate Kawira. We might want Kawira out. But the law says, do it within the law. They have a legitimate reason to remove her. Let them follow the law for removal of the governor. The law was never followed. And that is why the judge immediately seeing a court order from Meru High Court, seeing the procedures, how it was done, seeing the chaotic nature of how it was done. In the Munya case, the court said it is upon the speakers of the Senate to allow every member to participate. How many members were allowed to participate? Not even a third of the members of the Senate. How many abstained from voting? Who listened to the voice of the women senators? They were ignored. It turned out to be a butcher for women. So those are the issues that have been raised to the High Court through this petition filed by my good brother, my friend Mutuma. And I'm telling you, courts will always follow the law. Senate, Parliament imagines they're above the law. They are supervised by the judiciary. The judiciary is the last bastion that protects the rule of law. So Kawira has gone to say, you have valid grounds, but follow the law to impeach me.
out of curiosity, let me just get this from a layman's perspective. And we
Yes.
have seen it, here and there, where someone runs to court before their arrest because they are expecting an arrest and the courts will stop the arrest.
Yes.
Now, for the case of Kawira Mwangaza, she went, beforehand and the court stopped that process. I mean, someone would want to understand on what basis, on what grounds, and even if it is justified, that one should smell it from a distance, that this MCAs were planning this impeachment process and goes before them to the courts and the courts stop the process. Just explain to us what in the law allows her to go before the courts and have that order before the impeachment process, even though they have a real reason to get her out of office.
You can go to court after the fact. After you have been arrested, you can go to challenge that arrest.
All right.
You can go to court in anticipating
Yes.
that you are going to be arrested. Then you get what the law provides called anticipatory bail.
Yeah.
Like the one I did for Matiang'i.
Right.
So that you cannot be arrested, but you'll be told you proceed and you can stop an illegal prosecution, a malicious prosecution. Like Kawira knew the due process is not going to be followed. She went to court because the summons and the motion for impeachment had been tabled without due regard to the provisions of the law.
So what are we talking about here? Because, you've said, look, there's the rule of law, and the vanguards of the rule of law in this country is the judiciary.
Completely.
Okay? But there are court orders that have been given, not followed. Anybody can do whatever they want, it would appear. Court order is given, whether you follow it or not, okay, well, it depends on, what color the sky is that day. Then we are going back to the same court to say that this process, which was skewed or flawed here, we need you to now sort it out here. How?
The only thing
if that is not held in high regard in terms of what said should be followed, how then can you trust outcomes or processes?
The executive and the legislature wants to operate with the convenience, not with the law. The executive wants always to operate with the convenience. When pushed to the corner, when you hear teachers are going on strike, it is the same government that runs to court to get an order to declare that strike illegal. When that court says, pay these people their salary, then they say, this is a paper. The conveniency of the executive. When the court has spoken in their favor, they will always tell you, we respect the court order. When that order is against the citizens, when the order is against parliament, then they'll tell you, we'll not do anything. So, the court will continue issuing orders. Whether they are complied with or not, the court will not stop adjudicating and deciding matters based on the law. When Zuma was the president of South Africa, he ignored all the court orders.
All plus, yes.
The only one he complied with is when they sentenced him to go to jail.
Okay, sorry, I have to go back to that because it seems as though, it's not just in South Africa. Here, people ignore court orders.
Yes.
What happens?
And walk scot-free.
Yeah. What happens when a court order is ignored? The issuing officer of the court who gave that order is seeing it. They're not somewhere on Mars. They're seeing that this is being ignored. What's the recourse for something like that? Whether it is parliamentary, whether it is individual, whether it is... If somebody ignores a court order, let me ask it like this.
Contempt of court.
What is supposed to happen with the ignoring of a court order?
There is what is called a contempt of a court order. Once the court has spoken, because under the law, court orders are not mere aesthetic papers.
It would appear as they are.
But they have been made to appear like that. No private citizen has ever tried to disobey a court order.
This is what I was going to say, because you as a private citizen, you try to disobey.
You try. Today, 1 million policemen will be brought, including those ones in Haiti, to come and look for you. But when it is an order against the state, It is the same state that controls the police. The police are the enforcers of court orders. The judiciary does not have a police force.
All right.
This is where we get a problem. So that the orders against the state, the orders against cabinet ministers, the orders against principal secretaries, the orders against serious state house operatives become paper. What is the end of that?
Yes.
The country now starts going into saying, because we cannot get an order against government, because government is above the law, citizens take and read Article 1 of the Constitution. We the people, we are the sovereign. They go to the streets.
Wakili,
They take power by force. They eject those ones who are not ruling the country by the rule of law, and they have turned the country into a banana country. What we saw in the demonstrations was a clear indication that the government has refused to comply with the court orders. The government has refused to listen to what the Kenyans want, and people will force them to listen. The law provides for Article 37 to demonstrate. The law protects the sovereignty of the courts. And my appeal to anybody today who has power should be knowing that power is transit. Power changes. Those who are arrested are now being arrested. And those who are arrested now will be arrested next time. That is the beauty. Trump is now facing the law. He was the law himself.
but he's vying for president.
It doesn't matter. He's facing the law. If the courts clear him, he has faced the law.
Okay.
So what we are appealing to citizens and what we are appealing to states, respect the rule of law, respect court orders. If you are aggrieved with a court order, appeal.
So
I would dread, though, if we close this show without hearing his comments on a petition right before me here. And I hope it's okay for me, Wakili, to bring this forth.
Yes.
Someone is seemingly, bringing in a very interesting angle. And if I read it, this is a petition in the matter of many articles in the Constitution, including 1, 2, 3, 10, 19, 20, 21, 22, all the way. I mean, there are particular articles of the Constitution of Kenya. And in the matter of the violation, according to this petition, of Articles 38, 47, and 48 of the Constitution of Kenya, in the matter of County Governments Act number 17 of 2012 and Section 18. I mean, it's a lot of wordings,
Yes.
but what is important is that between and in the matter of the unprocedural and illegal, according to this petition, removal from office of the governor. We're having in the petitioner number 1, Honorable Kawira Mwangaza, and respondent Speaker of the Senate of Kenya. This is filed by Elias Mutuma. This is what we're talking about, essentially. Now, a lot of Kenyans would say then, Wakili, because it's very sad to hear that we can play after having a very good constitution promulgated, you actually saying that, okay, these things happen, and we have them on paper, and people are walking out here. Does it mean we have a weak judiciary? I don't know what you think, because you saying that people actually disobey court orders, Wakili, nothing serious happens. So we are playing around with either the courts, the judiciary, or we just don't have a strong judiciary because
it's just bad manners.
Or just bad manners, but they get away with bad manners. Or people are saved by politicians.
The courts are firm.
Are they?
The courts are firm.
To a particular people.
The courts give orders. The courts don't have mechanisms for enforcement of those orders. It is upon Kenyans to see, do we create a police division under the judiciary for implementation of their orders? Here is an order saying arrest the Inspector General. That order is to be served to who?
Okay.
The Deputy Inspector General to arrest his boss. Here is an order against the Minister for Interior. He is in charge of all security operators, excluding the military. How do you send a constable to arrest the Minister of Interior? Here is an order to arrest the chief of general, the defense forces of this country? How will the policemen go to the barracks?
The law is supreme.
The
Arrest
law
him.
is supreme.
Yes.
The practicability of enforcement is where there is the problem.
Okay.
What we are saying, the law is clear, but the law is not clear when it comes to practicability of enforcement. That is the issue. Until we deal with that question, because the only person you cannot arrest in this country or charge in a criminal matter is the president. Only one. But the offenses the president will do will start being kept in the investigation file. Immediately he leaves office. He'll take plea. So the law as it is, Kenyans have made the best laws. Where we fail, and I hope today a new Inspector General is being sworn in. I expected that question to be asked when he was being vetted. How will he ensure his officers will arrest cabinet ministers? How will he ensure his officers, whether which rank, can arrest anybody in compliance of the court order? The problem in this country is the selectivity of enforcement of court orders. And because of that, the rule of law has spilled to people, resulting into thuggery. The duration as a man who steals chicken, the process from him being arrested and being convicted is 2 hours.
It's very short, indeed.
The process of a cabinet minister or a political honjo takes 10 years. The matter has never started.
How should this be curtailed? Because it's a big question. I've had a very, very serious issue with this, that if the law is the law, it should be the law. If justice is justice, it should be justice. So how do we, for all, how do we see these excesses? Because they are excesses. How do we see them curtailed? You can't say that a justice system works well for one and then it doesn't for the other, or it works better for another. You can't.
We need a complete conversation with the law enforcement agencies. The moment we allow the executive to be the decider who becomes the Inspector General of Police. Did you see an advert for that post? It was not there. The president nominates whoever he wants. The moment we do a charade of who becomes the enforcement agencies leaders, if ESCC, if the DCI, if we have the Inspector General of Police, if we have the KRA bosses, if we have the KW bosses, we have the Office of the Director of Public Prosecution, the ESCC and the others, not having a competitive recruitment of people of integrity, people with track record. If we are rewarding cronies in those critical sectors, don't expect anything from them.
Should the county government of Meru be dissolved?
Just like that.
Should it be? Because, I mean, come on. It said, go back to the ground, sort this thing out, because it looks like it will continue to be a perennial issue. In your opinion, should this all just, let's start from the ground?
Because what if she's not impeached again this time?
There is a law that deals with dissolving of a county. It has been attempted in Makueni by Professor Kibwana when he was a governor. And the process went through, signatures were collected, they were verified by the IBC, they were sufficient enough, they were presented to the president, a task force was appointed, it came out with a recommendation that the county government of Makueni be dissolved. Under the law, it is the president's prerogative to dissolve or not to dissolve. The president exercised his discretion and refused to dissolve. If mayor want to take that process, the law is provided for. Take the process. But at the decision making, it rests with the president. He has not, he is not bound. That is how now the president will dissolve it, not because of the facts. He'll dissolve it based on political arguments. And that is why we have slaughtered this country at the political expediency theater. We are looking at things from a political angle, not from a nationalistic, patriotic angle, the day we know that politics has no role in the management and of the affairs of the state, politicians come, go, the state remains.
That's a good note to end on. Wakili DANSTAN OMARI, thank you for being here this morning. I mean, it's all a watch and see. It'll be very interesting to see what happens in the next couple of weeks around this. And indeed, if the rule of law is the rule of law, it should be the rule of law.
And apply across to everybody.
There you go. Thank you for being part of Kenya's biggest conversation today.
This is the Situation Room, the only way to start your day.